as a psychological principle, you're deceiving yourself, but not me. Hold on a second. Someone says, thanks for the shout out the other day. It made my day. Mandy Amos. No, you have to have changed your name. When I said in the Flynn video, I said Mandamus, and unless your name is Mandy Amos. Mandy, I believe you have to. I'm going to go check the history to see if that's your real name. Either way, hilarious and amazing. Okay, so everyone knows what happened in Flynn. Railroaded by the FBI, tricked into giving an interview. From that one interview, after 4 months of investigation, finding no derogatory information, they then get him to plead guilty to 1 count of lying to the FBI on a non-material fact of the investigation, incidental to any investigation about Russia, yada, yada, yada. Everybody knows it. If you don't know it, go watch the videos. Sullivan, who refuses to grant I'm seeing the government, but is it the Department of Justice's motion to dismiss?
Yes, it is.
Okay, so I can use Department of Justice, government interchangeably. He refuses to grant it, makes an open invitation to amicus curiae, outside people to come in and make motions to oppose the motion to dismiss by the government. Self-appoints Gleason. I don't know who the person is, but I know who they are now. To oppose the motion, Flynn's attorneys make an emergency mandamus petition to the Court of Appeals because they can't. Mandamus is to order a public official to render a decision that they are required to render based on their position. You can't make that to the judge who's not making it, so they make it to the Court of Appeals to say, order this judge who's a public official to render the decision he's required to render. The Court of Appeals gives him 10 days to answer. Am I right? And am I relatively accurate in my assessment that the Court of Appeals is saying you've got 10 days to save your ass or we're going to spank it type thing?
Yeah, I mean, typically what happens in a writ of, you don't often have a lot of writ of mandamuses that are like, even though they're often against the judge, the judge isn't the real party in action. So like in discovery disputes in California, for example, your only remedy often is a writ of mandamus. And really you're just asking it's really the opposing party. What's unique here is that both parties are in agreement. So you have a judge doing something. And so this occasionally comes up, but very rare. And so a typical response to a writ request is to ignore it. Most courts appeals just don't want to get involved because they think they can fix the problem on appeal. They can fix the problem on a formal appeal that has the whole record. So they got a good panel. That was the key for Flint. They got a panel. There's one Obama judge on it, but the other two are not. One's a longtime old school Republican and the other one's a Trump appointee. And so that's why, and particularly it's probably the long old school judge, conservative judge that grabbed the case and issued it. He's probably the lead judge on the panel by seniority. And so it was very unusual. I'll give Sidney Powell a shout out. She did a fantastic job in drafting the writ. Molly McCann does her work as an associate. They're a small team. I mean, they're smaller than my team. So they're a real boutique firm in truth. And they put together an excellent writ request that pointed out all of the problems with this. And they did a smart job of putting the political context in it, going back to that very first question about how you use the court of a public opinion to influence the court of law. And they cited Dershowitz's article, the Turley's article. They pointed out that a bunch of legal, well-respected law people on the left think this is nuts, what the judge did, and that it's high profile. So they're telling the Court of Appeals, other judges are going to go nuts unless you do something about this. And that's why it was so significant. I'd say high chance the writ's going to be granted.
Yeah, but I mean, it's not even like I didn't know about it until I read about it in the Forbes article with the Senaning versus the U.S., which was rendered a week before. So assume Sullivan doesn't have a clerk. Give him the benefit of the doubt, and I'll eat poop for suggesting it. Assume he didn't know about the decision that was rendered by the Supreme Court a week earlier. He knows about it now. So they're basically saying, get your stuff in order before you defy a Supreme Court decision, or we're going to come down on you.
And that's half of it. The other half of it was a fact I did not even know. It turns out the local D.C. courts do not have a local criminal rule, nor do the federal rules, of course. I knew that part, but I didn't realize the local court also had no federal rule to allow amicus in criminal cases at the district court level.
Okay.
And so she hammered this point. And she was like, look, the only reason why, and what was really impressive was Judge Sullivan had previously cited that very fact for arguing why he could not allow amicus in cases. So he looks like, I'll give you everybody a little secret about Judge Sullivan that I've been keeping quiet for a long time because there was a chance I was going to represent General Flynn in front of him. And it's that Judge Sullivan is known as being as dumb as a bale of bricks. So that there's no other way to put it. The guy is not bright. So it does, put it this way, it does not surprise me that Sullivan would contradict his own orders. I have had a strong suspicion, other people that have been in front of him and watched him, that his clerks have a huge influence on a lot of his written opinions. And that's why he made the mistake of saying, oh, I think General Flynn's guilty of treason. And it's like treason has no application here at all. It couldn't.
Something that was not crafted by the clerk.
I actually roped in a judge this way in Ohio many years ago. Very sophisticated judge, but not real bright on the rules of evidence and the law. He had hired all Harvard law clerks. He thought Obama was going to put him on the Supreme Court. And I figured out midway through that the marshal had messed up, had contaminated my case with the jury. Stuff that's not supposed to happen, but was clearly had already happened. And I realized my clients were really going to get lynched in live time. So I decided what I would do is make a bunch of evidentiary objections, but I would not file any briefs about them. I would only make them live in court, knowing the judge would make about 50 mistakes. And he did. I then moved for a mistrial. He figured out how I had trapped him, and he forced the prosecutor through behind-the-scenes conversations to basically give my clients a sweetheart deal that was incredibly generous. It was 10 times, literally 10 times more generous than what it was before trial, and they're about to win at trial. So Sullivan is of the similar. I have a strong hunch that he is of the similar streak, and that would explain these contradictory rulings.
Well, just so everyone appreciates the legal beauty of what you just said is when you make an argument in court and you don't want to submit written argumentation or written briefs, it forces the judge on the spot without the benefit of doing their own research through their own clerks or whoever to render a decision on the spot. And you can sort of exploit their understanding or lack thereof to make them cause them to render a decision which would be untenable upon further research on the spot if they don't know their stuff.
Exactly. Okay. So it strips them of protection from their clerks. And that's what I've done that on multiple occasions. A major problem with federal courts in America is the clerks are overwhelmed. They're these SJW type liberals who don't even believe in old constitutional principles. They believe that outcomes justify. They're not your classical liberals. I have a lot of friends who are on the left classically that are, including on federal bench, state bench, in all kinds of positions of power. But the new generation of left-leaning lawyers doesn't believe in the four core principles. They believe, hey, what outcomes should we have here? Let's manipulate the situation to get there. Some of them will be honest and say it that way. Some of it you can just see from how they handle things because when I was in law school, that's how they were teaching us. They were teaching us to how do I manipulate the law to get to an ending? Now, they did it carefully, but they did it in like first-year legal writing classes where the right answer was you wanted to change. I'll give you an example. What happened in that case was in the first-year law class, first semester, first year. So I'm there. They give us a test project where what we're supposed to do is to be an associate from we're supposed to imagine that we're an associate in a corporate law firm or any law firm, and the partner of the law firm has asked us, tell me what the law is in Wisconsin on this particular question, and it was whether adult disabled children should be able to recover for loss of consortium when there's an injury to the parent. And I researched the law. The law was clear. The law was clear that for a lot of dumb reasons, but because the fact they used to only value children based on their labor value, there's a lot of horrific things you find out about the law when you study its history. But in Wisconsin, you couldn't. If the adult, even if the adult was disabled, you couldn't recover for lost consortium. But I kept getting bad grades, and I was like, what? And I dug in, and it turns out they had written a template of the correct answer, and the correct answer was to pretend the law wasn't what it was, to just manipulate quotes from different parts of it and pretend that it actually already supported this outcome because the goal was your outcome is this. How do I manipulate the history of events and the history of law to pretend the law supports something it doesn't in fact support? And that's what's happening across the country. And so a lot of these clerks are really bad. So in federal court, I'm often battling the clerks, not the judge, unless the judge is an old school judge who doesn't care what the clerks think and does what they want. But any judge appointed in the last 20 years, and then some particular judges, Sullivan's been there for a long time, but there's some judges like Sullivan that have become very clerk dependent. And that's why I think Sullivan himself doesn't know often he doesn't put it this way, he doesn't understand the legal basics. I mean, why do you think the guy's asking for somebody else to defend him in front of the Court of Appeals and asking somebody else to defend him in the trial court? I mean, it's like, hey, I'm a judge, but can somebody tell me what the law is on this? So I want to hire this guy to do it? What the heck?
If he didn't know before, he's going to know it now that he's got counsel. And then incidentally, it's an interesting thing. You're basically, you're describing the arguing towards a conclusion. Or arguing from a conclusion as opposed to towards one, which is, when someone's got their decision made up, that's how they do it. Now, Sakaki Onse asks, as Sullivan has hired counsel, can he plan to appeal the D.C. Circuit's opinion, 99.765 against him, in order to extend Flint's torture? So that was one of the questions I had. So Sullivan, for anybody who doesn't know, has mandated counsel to represent his interests in responding to the Court of Appeals directive that he explained himself in adjudicating on the Flynn case. So you have a judge now who's got counsel to represent his own interests in the case where he's supposed to be representing the objective interests of justice. It's mind-blowing. But
I've never seen it. I've never seen a judge ask an amicus at a district court level to say, please tell me what the law is and if I can somehow use my power to hit this guy. And then, least of all, on a mandamus, go out and hire separate counsel using, I assume, governmental resources.
That was the other question. I was like, who pays for this?
I assume it's going to be government resources.
It's a high profile. From what I understand, the lawyer representing him now, or prospectively representing him, represented Kavanaugh during the hearings.
Yes.
Who pays for this?
Exactly. I'm assuming it's going to be coming out of the Judiciary Chamber. So all of this is highly unusual. To the question of whether a judge can appeal to the Supreme Court, traditionally, yes. A judge can challenge a writ from the Court of Appeals to the U.S. Supreme Court. But having private counsel involved, I've just never seen this before. So, and other people are like, what exactly? It just shows how nuts he is. Well, and in my view, how lack of confidence. See, what it really tells everybody is, hey, by the way, I have no confidence in what I'm doing.
No,
because the Court of Appeals is like, why do you need you're a federal judge. We're asking you what you did is right. You tell us why what you did is right. Don't go hire some other lawyer to tell us why you did was right.
To me, it doesn't. To me, doesn't signal a lack of confidence. It signal, and I'm not trying to judge Sullivan. I'm not trying to judge Sullivan. It to me, it signifies a total lack of honesty because he doesn't want to lie for himself. So get a counsel to come in and present the story so he can say, it's that's my counsel representing me. But the idea, imagine in every motion for recusal, the judge, the recusal of which is being sought, seeks counsel to represent them as to why they shouldn't be recused. It's mind-blowing in the most. This is jaw-dropping, rubbernecking from from the pedestrian perspective. But meanwhile, Flynn is still stuck in here. How much longer? We're going to get to that. How much longer is it going to drag this out for him? Does Sullivan hiring a criminal defense attorney signal he knows he broke some laws during the trial? Maybe some ex parte convos with Obama officials.
He doesn't think that way. My view of Sullivan, as soon as he issued that first order, my view was of what I'd heard about him. I've never practiced in front of him. It's just from other people that I talked to when I was looking at taking the case, is that he's just arrogant. So he's not going to think he did anything wrong. He's just looking at, okay, I need some political weight and I need some independent, smart lawyers to defend me in ways that I'm not going to be good enough, and I don't trust my clerks to be good enough to defend me. That's what he's doing. And so a judge like Sullivan, it tells you how accustomed to power he's been, that he thought he could get away with this even in the first place. And then he treats it like he's running a private law firm. Oh, okay, I'll hire these people out of the government treasury, these people out of the government treasury. If people think he hasn't done some other abuse of power in some other context, I think they would be mistaken given this course of behavior. But that's my take on him. No, he doesn't think he did anything wrong at all. I guarantee. Being in front of judges like that, they won't think they did anything. They're like those prosecutors on those innocent shows where they prove the guy's innocent, with DNA evidence and the rest. And they ask the prosecutor 20 years later, he's like, nah, you're still guilty. And it's like, oh, okay, how can you not recognize, it's that mindset. They're people that are not self-reflective. No,
it's amazing. And I definitely tend to think you're right. And so a lot of people have been asking this question, Joshua Cornelius, what kind of accountability, if any, does Sullivan and other corrupt judges, well, I'll rephrase the question in an objective manner, without judgment, Joshua, because I know other people are phrasing it this way. What accountability? My assessment, tell me if I'm right or wrong, minimal to none, other than an embarrassing Court of Appeal decision.
Well, you could be Alcee Hastings, a judge from the Southern District of Florida, find yourself impeached and subject to potential criminal cases because you took bribes, and you might end up becoming a congressman as he is today. So that gives you the kind of consequence that happens. In the federal side, very rare. There's two things that can happen. They can ethically suspend him from the bench. The D.C. Circuit has that authority. There's some constitutional questions about the scope of it, but they've done it to Manny Real in L.A. before. They've done it to a judge in Texas. I've unfortunately had to deal with both of those judges. Not pleasant. A smart lawyer some years ago figured out that if he could get Manny Real recused from every case, he would be in great business because of how many people hated Manny. So he flipped him off in court. He actually somehow got away with that. And now, of course, Manny has to recuse himself on all of his cases. That lawyer's business, boom. But the sad reality is that most judges face three legal consequences can happen. One is they can be suspended for ethical reasons by the Court of Appeals or the Supreme Court.
Which is never going to happen in this case.
Yeah, no, not in this case, not at all. They only do that in the most crazy cases or where the judge is on the side of the outsider and is messing with the establishment. So if they're upsetting prosecutors, upsetting big corporate lawyers, then they face sometimes that consequence. But otherwise, they have to be completely off their rocker. There was a judge, a case that had just come back from anger management training. He kept reminding me of that when he was in front of me. He's like, okay, I got to calm down. Anger management. So, that's the reality of it. Second is he can be impeached. Congress can impeach a judge. But there's nothing here that I consider that is grounds for impeachment. Professional screw-ups are not impeachment, in my view. And then for a judge or any other official. Now, the impeachment standard for judges is broader than it is for the president, but I still don't see that happening. And some smart Republican congressman will probably bring it up if Sullivan gets reversed to just get some political attention. Congress almost never takes action, except when something drastic happens, like number 3, which is the Department of Justice can investigate if a crime did take place, and so they have prosecuted judges. And so but that's not going to happen here either.
Well, I was going to say, give me one example where they prosecuted a judge. I suspect it's going to be on something more serious than a questionable overreach in a case.
Only for crimes. And one of the great impeachment cases, of course, was U.S. v. Nixon, a judge, I think he was from the great state of Mississippi, who appealed his impeachment because he wanted to stay a judge while he was in federal prison. So so you have some unique unique mindsets out there.